Right, I think we can start. Hello, good morning, afternoon, and evening to everyone. I know there are people from many, many time zones here. Thank you all for coming to this online session on human rights-based climate litigation. This is part of the Ecological Law and Governance Association's monthly webinar series. We meet on the third Tuesday of each month. I'll drop a link listing the webinars in the chat. They are recorded and they are available for later viewing as a resource. And we very much hope to engage with both the future webinars, but also the past ones. This very special webinar is also being hosted by the Ethics Specialist Group and the Climate Change Specialist Group of the IUCN World Commission on Environmental Law, and in support of the UN Harmony with Nature program. We're absolutely thrilled to have you all with us for what promises to be a wonderful session. It's an honor to have Christina Voigt and Gabriela Eslava with us, absolutely incredible co-panelists. I'm Shalini Iyengar, and I'll be chairing the session. Before we start, I wanted to quickly set out the structure for today's webinar. The panelists today will be speaking for about 15 to 20 minutes each. We'll first hear from Professor Voigt with an overview of rights-based climate litigation, the landscape as it now stands. Gabriela will follow with a presentation based on her experience with the landmark Colombian Future Generations case. And I will be speaking on some of the reasons underlying what has been called the rights turn in the academic literature. This will be followed by about 30 minutes for a discussion. Please feel free to send questions during this first hour in either the chat window or in a private message to me. We'll address those questions first in the Q&A, and then if we have time, we can also have a few direct questions from the audience. Without further ado, I know we have a lot to cover and not much time. Let me introduce the first panelist and turn it over to her. Professor Christina Voigt is a renowned expert in international environmental law and a professor of law at the University of Oslo. She really needs no introduction. Professor Voigt has published widely on legal issues of climate change, environmental multilateralism, and sustainability, and is also a frequent speaker at international and national events. From 2009 to 2018, she also worked as a legal advisor and negotiator for the government of Norway in the UN climate negotiations. Professor Voigt is currently co-chair of the Paris Agreement Implementation and Compliance Committee. She is also chair of the Climate Change Specialist Group of the IUCN World Commission on Environmental Law and a member of the IUCN Climate Change Task Force. Professor Voigt, over to you. Apologies, I think I'm just having some issues unmuting and muting. Just a second. The joys of being in a Zoom universe.
Yay. Thank you so much. Thank you so much, Shalini, for your very nice and very long introduction. Thank you so much for inviting me to the seminar. Thanks to Elga for organizing this seminar, as all the others in this series. It's wonderful to connect with you, or reconnect with you, and it's also very nice for the two respective specialist groups of the IUCN World Commission to organize something together. That's much welcome. I'm also very much looking forward to listening to Gabriela, who is going to speak after me. I'm very keen and very grateful for your willingness to share your insights. In my talk, I will look at the more general linkage between human rights and climate change. As you all know, there is so much happening right now, so many cases, so much litigation going on in many different fora, particularly in national courts, not so very much yet on international regional courts, so there's not so much to take stock of on that level. But I'll look at it from a more theoretical perspective of how human rights and the climate crisis interact. I will divide my talk into 4 parts. I will first talk about very briefly about the factual linkages between climate change impacts and human systems. Probably more than I need to say. I'm sure you all are more than aware of these interlinkages, but it might be helpful to set the scene a little bit for the seminar today. And then second, I'll talk about why climate change is a matter of human rights law. How does it come in? Where does it feature? And then third, I'll look or share some thoughts about the substantive climate content of human rights obligations. And here I'll focus primarily on the European system under the European Convention on Human Rights. I'll say a couple of words about the inter-American system, but not so much. I know there are other experts here that know much more than I do. And then I'll finally wrap up at the fourth part. As a caveat, I'll not talk so much about procedural issues of standing, of jurisdiction, of exhaustion of national remedies and these kinds of things, because that differs from jurisdiction to jurisdiction. So let me start first with the factual linkages between climate change impacts and human systems. As we all know, projected climate change impacts pose significant risks to natural systems as well as to human systems, and there's an interlinkage as well. The higher the temperature increase, the higher the risk. These are facts that we know, and these are facts that most of the litigation we're seeing right now is built upon. The Intergovernmental Panel on Climate Change, the IPCC, has issued several reports up to now. The sixth assessment report is bound to be released, hopefully later this year. But its special report on 1.5 degrees global warming that came out in 2018 was very important and extremely influential, because it projected that significantly higher risks will or have to be taken into account at 2 degrees warming compared to 1.5 degrees warming. But even at 1.5 degrees warming, we have to calculate in risks to human systems. And these risks include human exposure to increased floods, to water stress, freshwater stress, up to almost 50%, if not higher, depending on what region in the world we're looking at, to smaller net yields of crops, leading, of course, successively to issues of hunger and malnutrition, loss of livestock, reduction in food availability from fisheries and from aquaculture, negative impacts on human health, impacts associated with sea level rise and changes to the salinity of groundwater, which again affects freshwater availability, severe precipitation and damage to infrastructure, and increased likelihoods of extreme weather events. You see, it's a whole host of different risks. But in addition to these more or less direct impacts, climate change also interacts and intensifies poverty, conflict, instability, unrest, resource depletion, food insecurity, and loss of livelihoods. So each one of these direct or indirect impacts is deeply worrisome. But it is first when we look at the entire picture, when we look at the sum of all this, that the alarming picture, the really alarming picture emerges. Because addressing the causes and finding remedies to these adverse effects to human systems is an unprecedented challenge in scope, scale, and urgency. And it is a challenge that needs to be addressed in a rapidly declining window of opportunity. Now, second, let me turn to the question whether these issues make climate change, sorry, I just have to deal with something here on my screen, make climate change a matter of human rights law. Now, the climate effects that I just highlighted have a major impact on a wide range of human rights already today. And they could have cataclysmic impacts in the future unless ambitious actions are undertaken immediately. And I'll come back to that word immediately a little later, because it is a threshold for the effect on human rights within the European system. Among the human rights being violated or threatened are the rights to life, right to health, food, water, and sanitation, the right to a healthy environment where it exists, And we know on the international level, we only have very few international treaties that recognize a human right to a healthy environment, while in domestic legal systems, we have many countries that have constitutional provisions, and Colombia is one of them. Norway is another one that actually recognizes a constitutional right to a healthy environment, but also right to adequate standard of living, to housing, property, development, culture. There's, again, a whole host of human rights that are already today affected by the impacts of climate change, and potentially even more if we don't mediate that challenge. Now, the matter of climate change is being addressed on the international level in different treaty systems. Of course, you know, on the international level, we have the Paris Agreement adopted under the United Nations Framework Convention on Climate Change. And in domestic laws, we have often very special climate regulations, climate laws, climate acts. But these treaties, both internationally and domestically, they do seldom, if ever, address the human impact of climate change. They're very technical treaties dealing with emission reductions and technical regulations and what have you, but in very few circumstances, if at all, deal with the human impact of climate change or even human rights. So these human rights impacts are usually outside their scope, and they function in different silos. And this is aptly expressed, for example, in the preamble of the Paris Agreement, as you perhaps know, where it is stated that parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights, and then follows a whole host of different aspects that are mentioned there, indigenous peoples and migrants and so forth. But it refers to their parties, their respective human rights obligations. And that means that it refers to already existing human rights obligations that parties need to take into account when addressing climate change. So in other words, the Paris Agreement in a way throws the ball back into the human rights court, not any particular court, but just metaphorically speaking, and reminds state parties to the Paris Agreement of their existing human rights obligations. And I dare believe this is one of several triggers for why we currently see such a rise in human rights-based climate litigation. But there are other linkages as well. States have the obligation to ensure or protect, respect, and fulfill human rights to everyone within their jurisdiction. And the foreseeable and potentially catastrophic effects of climate change on the enjoyment of that wide range of human rights that I already mentioned everywhere in the world, these effects give rise to extensive duties of states to take immediate actions to prevent those harms, to address them where they already materialize themselves and prevent any future harm from happening. Moreover, approaching climate change from a human rights perspective also highlights the principles of universality, of non-discrimination, and also emphasizes that rights are guaranteed for all persons, including vulnerable groups. A human rights-based approach could serve as a catalyst for accelerated action to achieve a healthy and sustainable future in a wider context. And importantly, and I assume, Shalini, that's probably what you will talk about at the end of the seminar, very different from the international climate regime or even the international environmental regime, the observance of those human rights can be ensured by specialized human rights courts. So if we are able to link climate impacts to specific existing human rights, then we have an avenue open to specialized courts, something that we do not have when it comes to international environmental law, international climate law in particular, which makes, of course, a human rights-based approach a very sought after avenue. And I'll address that question also a little bit later, whether climate change belongs into human rights courts. Now I will now turn to the third aspect, to the content of human rights obligations with respect to climate change. And that's in a way the billion-dollar question here. What actually do human rights or the observance or the protection of human rights require states to do in order to live up to their human rights obligations? Now, when it comes to human rights, we know there are procedural, there are substantive, there are special obligations towards vulnerable groups. Much has been written, much has been said about this already. And I want just to highlight the very important work by the UN Special Rapporteur on Human Rights and the Environment, who does excellent work in highlighting the close linkages between certain different environmental issues, but in particular climate change and human rights. But here I will focus only on the substantive obligation. What is it? What is the climate dimension, if I may say so, of human rights obligations? So to start with, it is important to mention that the European human rights system is somewhat different from the inter-American one. For those of you who know a bit about the inter-American system, then you know this already. You can just blank out for a little while. But for example, the inter-American system contains a right to a healthy environment. The additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights, the Protocol of San Salvador, the San Salvador Protocol, establishes in Article 11 a right to a healthy environment, where it says that everyone shall have the right to live in a healthy environment and to have access to basic public services. So based on that protocol in the inter-American system, the practice of the Inter-American Court on Human Rights, which is based in Costa Rica and San Jose, has been rather progressive in filling this right with content and substance, in particular in its advisory opinion on environment and human rights, which was released in 2017, and more recently in its contentious case and its judgment on the contentious case of indigenous communities of the La Cajonhat Association in versus Argentina, which was released earlier last year, about a year ago exactly. So in this situation, we have the Inter-American Court on Human Rights, who is very active, but not yet on climate change, but on formulating the substantive content of a human right to a healthy environment. Now, the European system is different, as I already indicated. There is no mentioning whatsoever of any environmental aspect within the European Convention on Human Rights, over which the European Court on Human Rights has jurisdiction. There is no reference to environment or climate change or anything in the convention, neither is there any additional protocol that would recognize a human right to a healthy environment. But that does not mean that the European system is blind to the environmental conditions which are necessary for the enjoyment of other already existing human rights. So the European Court on Human Rights has long recognized, has really fairly long practice on this, that parties have positive obligations to secure human rights. And this imposes the duty on national authorities, on state authorities, to adopt reasonable and appropriate measures to effectively protect rights and to provide deterrence against threats, including against environmental threats and against risks that may materialize even in the longer run. And there's a rich practice of the court in this respect. I won't go through this. This would be exhausting, this seminar. But so far, the court has not yet issued any judgment that addresses climate change as an issue of human rights. So primarily, the practice of the court is on more traditional environmental challenges like waste depots and air pollution, that sort of thing. And it looks at Articles 2, which establish the right to life, and Article 8, which establishes the right to private life. So these are existing rights, but these are considered in the context of environmental risk to the enjoyment of those rights. Okay, so no climate case yet to decided. I'll come back to a case that is pending at the European Court on Human Rights at the end of my talk. But the central question, therefore, is, and it's more of a theoretical question currently, because, as I said, we don't have any practice yet. But the central question is, when do states actually have fulfilled their human rights obligations to ensure individuals' human rights obligations with respect to avoiding the threats from climate change? Now, the relatively easy answer is, that's just the first shot, is that when the measures that parties adopt, that states adopt, are aimed at and are effective to prevent dangerous levels of climate change that has these effects on human system and eventually human rights, as I highlighted in the beginning. However, given the current trajectory of global warming, which is, as we all know, it's projected to exceed safe levels. Currently, we know if business as usual continue, we're probably going to hit 5 degrees warming rather than 1.5 degrees. So the currently projected levels of global warming exceed safe levels. And therefore, the adopted measures so far need to be presumed to be inadequate, because they are not in line with what would protect humans, individuals against human rights violations. So which climate measures would be reasonable? Which climate measures would be appropriate in terms of complying with human rights obligations? When answering this question, the Human Rights Court, or any court that is asked to look at this question of climate mitigation, or the level of ambition in terms of human rights obligations, should take into account elements of international law and therefore interpret human rights obligations consistently within the legal environment in which they exist. And this applies in particular to the Paris Agreement, to which 190 parties, and a couple of days, even the US again, are a party. So Article 2, the paragraph 1 of the Paris Agreement sets out the global goal of holding temperature increases to well below 2 degrees centigrade and pursuing efforts to limit increases to 1.5 degrees. And again, this global goal is informed by science, by best available science provided by the IPCC. And the IPCC is very clear on what exactly needs to be done in order not to overshoot that threshold that is set in Article 2 of the Paris Agreement. The IPCC says that in order not to overshoot that goal, global net CO2 emissions need to be reduced between 40 and 60% from 2010 levels by 2030, and then need to reach net zero, global net zero emissions around 2050, around the second, at the mid of the century. So it means we have about 3 decades left, or every single state has 3 decades left to basically phase out greenhouse gas emissions. And if they cannot phase out, they have to be balanced out by removal, so that this net sum is zero. And this is very clear. That's something that can be used in human rights litigation, as well as the standard that needs to be interpreted in what states actually need to do and to achieve in order to protect, not to violate their human rights obligations. To this extent, parties also have committed that parties to the Paris Agreement, that each party's nationally determined contribution to the Paris Agreement shall or will reflect its highest possible ambition. And this is a due diligence obligation that we maybe also already know under human rights law, that there's usually the standard of care of due diligence, or according to which parties need to take all appropriate and all adequate measures to achieve the temperature goals of the agreement. And this includes a duty of conduct to use all measures at their disposal, especially the adoption and implementation of laws and regulations, including to address private behavior monitoring, as well as their enforcement, in order to reach that goal of global net CO2 emissions around 2050. So in light of the magnitude of the climate risk, in light of the clear science that we have, and the urgency of the task, because we have no time to lose, really, this due diligence obligation therefore implies to take all appropriate and adequate measures to prevent climate change. And this again implies taking all measures that are not impossible or not disproportionately or economically disproportionately burdensome, with the objective of reducing global greenhouse gas emissions to net zero by around 2050. So this also implies, and that makes it a little difficult, of course, but it implies that states with greater capacity and with greater responsibility have to reduce their emissions to zero faster and maybe even deeper before 2050, in order to give states that might need longer to reach net zero emissions the possibility to get there too. And here we're just thinking of states like India, China, Pakistan, whoever, who may take or need a little longer than other states that are ready to go down to zero pretty much immediately. But by 2050, basically the entire world needs to be there, which needs some sort of differentiation of who needs to go first and who needs to go faster. States also need to ensure that public and private investments are consistent with a pathway towards low greenhouse gas emissions and climate resilient development. That's another goal that's written into Article 2 of the Paris Agreement. It's somehow in the shadow of that temperature goal about which everybody seems to be talking, but just a little further down in the same article, we also have a goal that public and private investments need to be consistent with that kind of development, and that also, of course, is a call to action for states to regulate their economic investment and trade sectors. So in their measures, states need to ensure that their own carbon neutrality, if they want to achieve carbon neutrality at home, do not lead to rising emissions somewhere else in the world, so that by just relocating highly emitting industries to other parts of the world and just buying products and consuming them at home, they can get to carbon neutrality. That is not possible if the entire world needs to reach carbon neutrality around 2050. So just let me cut that long story short, but it's an important discourse to be had, because this all informs what is the duty, what are the obligations of states in order to comply with their obligation, with their human rights obligation. It's a complicated picture, but is one that really needs to be thought through, and currently is being thought through both by academics, but also by judges. In sum, it implies that every single state needs to employ its highest possible level of ambition and act according to its best capabilities, so simply do as best as it can in order to reduce its greenhouse gas emissions toward a trajectory of reaching net zero or carbon neutrality by 2050. This level is more rigorous if the risk is higher, like it is with climate change, and it involves the requirement of a state to use all measures at its disposal to address that risk. So put simply, complying with human rights obligations requires dramatically accelerated climate action. By not reducing emissions at that level of ambition, states fail to prevent foreseeable human rights harms caused by climate change, and therefore violate their obligations under international human rights treaties. And this is exactly the claim that 6 Portuguese children and young adults have brought to the European Court on Human Rights late last year. It is a claim directed at 33 member states to the European Convention of Human Rights, which are all EU member states, plus a couple of other states around it, including Norway, for example, which is not a EU member state. And those 6 Portuguese claimants say that those 33 states, which are all developed states, they are violating those children and young adults' rights to life and to private life under Article 2 and 8, respectively, of the European Convention on Human Rights, by not taking action at the level required to address or to keep global temperature increases to 1.5 degrees. And what that applies is what I just tried to line out to you. The case is called Youth for Climate Justice versus Austria, and then there's a whole long case or list of states against which it is addressed. As I said, it's 33 states. The case was admitted, interestingly enough, earlier this year or late last year, I can't even remember right now. And now those 33 states have been requested to reply to the claims by those six children and young adults from Portugal. And in their claim, and I have that here in front of me, the claimants state that the respondents, which are those 33 states, have breached the duties under the European Convention on Human Rights, Article 2 and Article 8, because the systemic duty requires not only to the mere existence of appropriate systems to address climate change, but also that they have put into practice and are effective. Climate measures have to be effective to address that problem of climate change. It follows that assessment of compatibility of a state's mitigation measures with the 1.5 degree target must be based upon the emission reductions actually entailed by the measures adopted by a state, including emissions that materialize outside their territory, which is very interesting and something that we're really sitting at the edge of the chair to see what the European Court on Human Rights will have to say. So in brief, what those six children and youth are saying is that those 33 states have not, by not putting climate targets into their nationally determined contributions at the level of their highest possible ambition, is violating the positive obligation to adopt all necessary and appropriate measures to ensure the human rights of those six children and young adults. Now let me wrap up. The picture that I try to paint here is, of course, it's a complex one. It is not an easy one to comprehend. It is something where many legal lines have to be drawn, and many considerations need to be taken into account. And as you probably know, we had our own particular case here in Norway, which was decided right before Christmas, where the Norwegian Supreme Court decided that by handing out new oil exploration licenses by the Norwegian government, that was not a violation of the Norwegian constitution's right to a clean and environment. In this particular case, the court played the ball back to the parliament and said effective measures have to be established by the parliament, but not by the court. But in other cases, in other countries, Supreme Courts have decided differently, and we will hear from Gabriela about the situation in Colombia. In Norway, that wasn't quite the case. However, it might be an opportune moment to consider the development of a human right to a clean and healthy environment on the international level, and many initiatives are in motion to establish on the UN level, or at least on the regional level here in Europe, the recognition of a human right to a clean and healthy environment on a supranational level. Because the expectation is that a right to a clean and healthy environment can set out a more appropriate framework for weighing the various environmental and social implications of climate change and other environmental challenges in a much more holistic and comprehensive manner than just by looking through them through the very small lens of a right to life or a right to private life. It would also better recognize the planetary emergency of a climate crisis and biodiversity crisis and all the different crises that we certainly currently see and are very well documented by science. As I said earlier, the right to a clean and healthy environment is already recognized in law by more than 150 states in their domestic legal systems. One way to recognize it, for example, within the European system would be to adopt an additional protocol to European Convention on Human Rights that recognizes a right to a clean and healthy environment, and such an initiative is underway. Whether it's going to be successful or not is something that we'll have to see. So finally, let me answer the question of whether climate change is a matter for human rights courts. And you can probably already guess from my previous elaborations, I think, yes, it is absolutely. Because when states are not ambitious enough in their human rights legislation, in their human rights actions, in their policy, in their laws, and when they do not live up to their human rights obligations, to their positive obligations to prevent harm to the individuals on their territories, this is a matter of law. This is not a matter of politics. It does not mean that a court would need to be prescriptive and would need to tell states exactly how much they need to reduce their greenhouse gas emissions. Very few courts would ever do that. The Supreme Court in the Netherlands in the Urgenda case did it, but I think that is quite an exception to what courts generally do. But it could, for example, be possible for human rights court or for domestic or for Supreme Court to ask whether the measures that a state has adopted, whether they are adequate and appropriate to prevent humans, individuals, citizens from climate change harm. And a test question for this that a court could ask is, are the measures aimed and effective for achieving a rapid, deep decarbonization and eventually a global phase out of greenhouse gas emissions around 2050? And if they're not, a court may want to tell states to revisit their policies, say, go home and do better. It doesn't have to be prescriptive, but it can recommend or require, request to raise the level of ambition in their national policies, leaving the decision of what measures exactly to the politicians and decision makers, but it can turn the ball back into the parliaments and raise the level of ambition. So ask states to revisit their policies, their plans, including their regulatory and administrative framework, with the aim not just of doing better, but doing the best they can, their utmost to significantly raising ambition. Thank you very much.
Thank you so much, Professor Voigt. That was fascinating. I'm going to quickly turn over to Gabriela. Just to quickly introduce her, Gabriela is an MPA in Development Practice student at the School of International and Public Affairs at Columbia University. She is a Colombian lawyer. She worked as a researcher at Deforestation, where she led the first climate change and future generations lawsuit in Latin America. This landmark case resulted in the recognition of the Amazon rainforest as an entity subject of rights. We're thrilled to have Gabriela here and look forward to hearing from her presentation.
Thank you very much, Shalini. I want to start by thanking you for inviting me to this webinar. I'm very honored to be sharing panel with Professor Christina Voigt, and I also want to share the organizers, ELGA and IUCN. If you let me share my screen, I prepared a presentation. I think it might be easier for everyone to understand because I will be focusing on the Colombian context. I will try to explain how we try to put in practice all the frameworks and concepts that Professor Voigt just explained. So I'll start with, I have the intention to cover these 3 different topics in the following 15 minutes. So I will want to walk you through the process we follow for the first climate change and future generations legal case in Colombia, and one of the first in Latin America. I will also like to share some of the reflections on the main arguments that led the Supreme Court of Colombia to recognize the Amazon rainforest as a subject of rights. And if I have time at the end, I would like to share some reflections on what has happened in the past 3 years after that legal victory, as it has been called. So to start with the legal case, I will try not to stop in the details of the Colombian jurisdiction, but I walk you through the relevant facts, legal research, evidence, the court's decision, and the implementation. So for the relevant facts, we had to start with the question, what is the main cause of greenhouse gases? This research started in 2016. So at that moment, we had the Paris Agreement, but we didn't have this big movement of Fridays for Future or young people in different countries claiming for the protection of their rights. The knowledge we had at the Justicia on climate change was just the Paris Agreement. We didn't have a big idea on how climate change worked in practice and how our country was being affected by climate change. Then I'll reflect on why is this important and who is responsible. So our research took us to deforestation in the Amazon rainforest, and that was news to us. So in 2016, we expected that the main cause of greenhouse gases in the country was going to be related to industry or our overcrowded cities, but we ended up finding that the official sources from the government had tracked deforestation, and it was located in the Amazon region. So we found that 36% of the greenhouse gas emissions in Colombia came from the forestry sector, that 98% of those 36 came from deforestation. And the latest data we had at that time was that it had been an increase between 2015 and 2016 of 44% in deforestation. And also that 39% of deforestation in the country was located in the Amazon rainforest. And I will add that this is important because we were living the first year of a new context, a new political context in the country, that is the post-conflict after the government signed the peace agreement with the FARC guerrilla, ending one of the longest armed conflicts in the continent. So in this context of greenhouse gases and deforestation, we needed to understand better how this related to human rights and to future generations. So we continue our research on the different consequences from deforestation, and we found that it affects the water cycle, and this might seem obvious. For us, it wasn't so at that moment. We found that a scientist, a Colombian scientist from the IPCC, has dedicated his research to study the relation between the Amazon rainforest and the Andes mountains. So basically, he has this beautiful image to share in which all the rain that is produced in the forest, with the process of evapotranspiration and the help of the wind that comes from the south of the continent, when this water reaches the Andes region, it becomes the water that supplies almost 70% of Colombians. So whatever happens in the Amazon is affecting the capital and the Andes, where the most of the population is located. Deforestation could also lead to landslides. We have been affected by landslides in many different municipalities of the Amazon, and most vulnerable communities have suffered from that. We also found that Colombia reported the different climate change scenarios in its INDC to the Paris Agreement, and it said that if the warming trend continues as it goes, Colombia should expect to have 1.6 degrees Celsius warmer environment for the first climate change scenario that would be between 2040 and 2070. And our main challenge was to show that all these facts, all this science on climate change had a human face. So we needed to translate this into actual people who had their lives under threat. And that's how we ended up having a group of 25 different children and young adults. The youngest was 7 at that time, and I was the oldest one. And for full disclosure, in this presentation, I'm sharing 2 hats. I was part of the legal team behind this lawsuit, but I was also one of the plaintiffs. We came from 17 different cities and municipalities of Colombia. So if you see here the map, if you draw a diagonal over Colombia, or everything that is south of the diagonal would be the Amazon. So almost half the country is Amazon region. And we came from different places with different ecosystems, with different realities. We had some 2 plaintiffs from the islands, and we wanted to show the judges that deforestation was not only hurting or damaging this biodiverse ecosystem, but that it had a relation to climate change, and that climate change had a relation to sustainable development that is part of our national constitution, and that that is not an abstract idea, that affected human lives. So this was the group of 25 plaintiffs, all of them with a history of activism in their schools, in their cities. So the next step we had to follow was to try to put this in the legal context. So who's responsible for taking care of climate change and future generations' rights? And we found that the Colombian government had at least two different types of obligations or duties related to this. So as Professor Voigt just mentioned, our national constitution includes the right to a healthy environment. It says that everyone has this right and also the right to participate in the decisions that affect the environment, and that the government has a duty towards sustainable development. Our national development plan, it's a law that every new president presents to Congress every 4 years. And the National Development Plan at that time stated that the maximum amount of deforestation allowed was something around 90,000 hectares per year. And the latest data we had was almost double that amount. In the international context, this was 2017, and Colombia was in the process of ratifying the Paris Agreement. So we mentioned the preamble of the Paris Agreement, and also a joint statement between Colombia, Norway, UK, and Germany, according to which Colombia would receive some resources if it was able to stop deforestation, to reach zero net deforestation by 2020. And we basically were showing that the official information from the government was enough evidence to say that the government was not acting to fulfill these legal obligations. I will try not to stop in the details of the legal action, but as you might be aware, many countries have been facing climate change cases, and there are some common questions to these cases, like who has legal standing? I apologize for the background noise. Who has legal standing? How is it possible that who don't, like a group of people who don't live, all of them in the Amazon rainforest, are demanding the protection of this ecosystem and are demanding the protection against some threats that will that have a high probability to occur in the future? How can we prove causation? How can we prove that climate change is the only or the main reason behind those violations or threats? Who are future generations? And which kind of legal action to use to not stop in the differences between the climate, the legal actions we have in Colombia. We choose the tutela. Tutela is a legal action that is part of our national constitution, and what is beautiful from this action is that the judge has 10 days to decide the case, because it's an action that every citizen can file whenever their fundamental rights are being violated or under threat. So given the urgency of this matter of deforestation increasing in a post-conflict framework and its relation to climate change, we wanted to show that urgency to the judge. That's why we choose to file a tutela action. The evidence we used, and this was key, we wanted to show the legal system that science was important in our case, that we were not we were not talking about something that was not happening or that was not real. So we contacted scientists from the IPCC. We even had an amicus from James Hansen, who has been working in attribution science. We used the early deforestation warning system that the government produced itself, the greenhouse gas emissions inventory, all the information that our government prepared for the COP. We were showing them, like, you have been doing this and you know that there is a problem, use this information. And also scientific papers on the relation of the Amazon rainforest with other ecosystems in the country. Our main claim was the protection of our rights, and I'll stop, I'll share more about that in the following minutes. And we had three other additional claims. We wanted an action plan to reduce deforestation, to fulfill the joint statement that Colombia had signed with other countries. We wanted an intergenerational pact for the life of the Amazon. So we were aware of the dimension of sustainable development and how it was important to talk about intergenerational equity in this case. And we also wanted the Amazon municipalities to update their land management plans because after reviewing them, we found that none of them had anything related to climate change or adaptation to climate change. So after that, this is a very broad brief of what we argue in the case. We said that deforestation had a relation to climate change that was proved by science, that the government had failed to act regarding its obligations on this subject, and that failure to act was producing a violation to the right to a healthy environment, that the judge could go to the Amazon and see how deforestation was affecting the biodiversity of that ecosystem, and that had a relation to the lives of these 25 plaintiffs. And that violation that was happening put a threat to the right to life, access to water, food, and health of each of these plaintiffs. So in the lawsuit, we explain how each of those rights would be affected for each of the plaintiffs. To wrap up, this was a case in which we needed help from some principles that are part of our legal system, and we knew this was not the case a judge was used to. So we emphasized the principle of solidarity. According to our national constitution, every Colombian citizen has a duty of solidarity, and we interpret that duty in three dimensions. Solidarity to other human beings, to future generations, and to other sentient beings. And this was key because it was the base of the Supreme Court used in its decision. So in April 2018, the Supreme Court granted our rights and declared and ordered all the plans we were asking for. And also it included an order that we weren't asking for in the lawsuit, and it declared the Amazon rainforest as a subject of rights, and it said that the Amazon had the right to be protected, preserved, maintained, and restored. Maybe in the Q&A, I'll be able to share some of the reflections on this part of rights of nature, but in the past 3 years, we have been living some implementation challenges. For example, what does it mean that an ecosystem is a subject of rights? How does this relate to climate change and the complexity we were talking about before? How can different agencies from the government work together to solve the climate change problem? How can we stop seeing this as only a scientific discourse, and how can we translate the human rights claims into actually efficient policies to adapt to climate change? How can we ensure that all the relevant stakeholders participate in the implementation of these litigation cases? How can we take this legal victory in quotes beyond paper, and what have been like the negative externalities of the case? So with that, I thank you for your time, and I welcome any questions you might have.
Thank you, Gabriela. That was fascinating, and looking forward to hearing more about these implementation challenges, especially a bit later. I'm going to quickly share my screen for the final presentation. Right. I'm hoping you can all see the screen. Yes, so my presentation today is Ethos, Pathos, and Logos. And this, I'm Shalini. I am an environmental lawyer and a PhD student at the Department of Anthropology at Yale. My research arose from what I was seeing as a gap in the literature, which is understanding what the lawyers and the activists filing rights-based cases were citing as the reasons for these cases coming to court. What I found particularly fascinating, and this is something that I perhaps won't go into the presentation in the interest of time, was the fact that these cases are particularly, it seemed like an emerging movement, and it seemed like it tells us something about where the climate change litigation might be going. But for this presentation, I want to focus on essentially two main questions. Why were human rights-based arguments being used in litigation? And why was there such an increase in these cases over the course of the past decade? So these cases, my methodology for this was largely extremely qualitative. I did a number of interviews, semi-structured, with the lawyers and activists filing these cases. And what emerged from them was not just a constellation of a lot of actors, and I'm happy to go into it in more detail later, but the why human rights question. And this I found particularly interesting. A lot of lawyers, and this goes to what Gabriela was saying a bit earlier, were talking about how in human rights-based climate litigation, there was a focus on both the human and the rights aspect. So these cases became a very integral way to humanize what was often seen as a more technical subject. People perhaps could not connect with the polar bears alone, but these cases have, if you've noticed, there are a lot of first-person narratives in a lot of the human rights-based cases. You hear evidence, and this is a key, I think, way of putting a human face on the climate problem. And so human rights becomes really important as a part of that. The second reason a lot of the lawyers and activists cited was it made common cause. And this again goes to the solidarity principle, and we're all in this together, but this argument was made in different ways. Firstly, human rights allows for the fact that you can make common cause across jurisdictions. You don't necessarily need to be inhibited by any limitation, and you have a very robust way of saying that there is an obligation to take action because someone else might be impacted. A lot of lawyers also cited that there was simply a lack of adequate climate legislation. So in this case, human rights becomes a supplementary gap-filling kind of mechanism, which is what we saw in a number of the cases. There simply isn't a statutory basis in many countries to move for a climate obligation on the government, or where there is, it's woefully inadequate. So in this case, human rights becomes a way to get these issues on the agenda. The fourth point, and this is something Professor Voigt was mentioning earlier, human rights has its own architecture. There are a series of specialized courts and tribunals all over the world. At the international level, there are also, and this is key, a lot of domestic comfort with these sorts of arguments that are being made. A lot of countries are very used to hearing rights-based arguments. They are familiar with them. So in that sense, these cases become more about extending existing obligations along similar pathways to a new substantive field, and not necessarily creating what they would call new obligation. And we see this in a number of these cases. And finally, the reason that is often given for imposing these sorts of substantive obligations is the fact that human rights, and this is a strength that it has, does impose not just a procedural obligation, but a substantive one. What do I mean by that? Some of the lawyers mentioned that if you win on a technical point, I think the Heathrow case was an example of when that might go wrong. You're essentially saying that if you fix that procedural deficit, you can come back and then argue the case differently and potentially win. Whereas if there's a substantive obligation like human rights, then that pathway is just foreclosed for, and then you have a much stronger basis to say that certain actions should not be taken. So these were also the reasons we were hearing for why human rights became such a powerful, discursive, and legal frame for these cases to be argued. Then the question, why the rights turn? The Inuit petition happens in 2005, but it's really 2012-ish that the cases start piling up almost. I mean, piling up is a bit of an exaggeration given that we have maybe 30 odd cases in the past decade, but it certainly is startling in comparison to the previous period. And certainly one can also argue that these are the cases that get the most oxygen and energy. And so when I asked the lawyers and activists, what I heard from them was that the first and perhaps the most obvious answer was that the linkage between human rights and climate change simply took time. The Inuit petition happens in 2005. The case might not have succeeded, but it did create quite a conversation, particularly the international level, and a number of actions begin being taken almost immediately afterwards. And this involves the small island states, this involves the UN Special Rapporteur on Human Rights and the Environment, just beginning to link these, I would say these fields that were never siloed, but at the time they were seen as distinct, human rights and environmental law, and these linkages begin to be made. So by the time the Inuit petition creates this frame, by 2012, you have it not being so surprising anymore. And so these cases become easier to just argue. Secondly, for a lot of my interviewees, the answer I got was Urgenda success. Nothing succeeds like success, as the saying goes. And the fact that you had this startling success in many cases, and Professor Voigt alluded to it, that Urgenda is still seen as quite an exception in terms of the strength of the commitments it was able to impose. And at the time, it was a really early example of what might be possible. And one of the interviewees I spoke to said that, when the case was being discussed in its planning stages, a lot of lawyers were like, that's not going to succeed. That's just not happening. But when it did succeed, there was immediately an interest in, okay, wow, so how can we make this happen in our jurisdictions? The third thing that I was hearing was international climate negotiations, and that actually cut both ways. On the one hand, the success of the Paris Agreement has really given a huge boost to a lot of efforts, and this is something that came out in both Professor Voigt and Gabriella's presentations when they were talking about Paris Agreement becomes a touchstone. You don't need to renegotiate these terms anymore. Human rights comes onto the agenda. At the same time, however, when a lot of these cases were being argued initially or planned, because of course, as we saw in the last presentation, cases take a long time to conceptualize and come together, there was a feeling that the international space was just not living up to its promise, because we had UNFCCC in the 90s, and there didn't seem to be a very cogent application of many of these principles. And so there was a frustration with the international space, which is why people wanted to turn to looking at domestic spaces or just different ways to make that argument. So increasingly now, when you have an international and a domestic that are more aligned, it will be interesting to see what that very productive intersection can create. The fourth, and this was actually cited by every single interviewee from the Global South, was devastating natural disasters over the past decade, whether it's Typhoon Haiyan or floods in India and Pakistan. You had a lot of consciousness that we can't let this happen again. The most vulnerable are being the most affected. And the improvement, I think, and I'll come to this, the climate science question, made it very clear that there were direct linkages between what was happening. Maybe, and this was surprising to me going in, because there's a lot of hypothesizing in the academic literature that improvements in climate science are driving a lot of these cases. And the response from the interviewees was very mixed. And there are maybe a few reasons for it. Some argued, almost all of them argued, that climate science was absolutely at the bedrock of a lot of the arguments. But many of them also said human rights arguments exist on a conceptual plane that is separate from the science. So regardless of how well established the science is, if human rights are being impacted, then that's an argument you make anyway. Others were more, they caveated it by saying that it really depends on the jurisdiction, where in certain jurisdiction, the human rights impact have to be directly linked to science. The science has to be very, very sharp on attributions. The improvements in that are also interesting. But this was a relatively more mixed terrain, which I find quite interesting in terms of the responses I was hearing. I'm conscious of time, so I'm just going to stop the sharing and perhaps turn it over to questions from the audience, and looking forward to them. Thank you. If you have questions, I think given the size of the group, perhaps either put them in the chat box or use the raise hand function, and I can just call on the persons doing so. While we are waiting for everyone to gather their thoughts, I was wondering, Gabriela, do you want to speak a little bit more about the implementation challenges you were discussing? Because I think that's a particularly fascinating aspect of the Colombian case as well.
Thanks, Shalini. Yeah, so it's been 3 years since this decision, and it has had like a direct effect on the government planning how to stop deforestation, receiving more resources, having a stronger position related to climate change adaptation. Whereas before the Paris Agreement, the public discourse from the government was that Colombia was doing great in relation to climate change mitigation, but our main challenge was adaptation. So we're starting talking about adaptation. The thing is that sometimes the sense I have is that we put so much faith into litigation to solve structural and complex problems that when it takes time to implement that and to turn those decisions into policy, people disengage a little with the human rights discourse. So it's wonderful to see the new relation to nature that has come after saying that the Amazon rainforest is a subject of rights, to have a new generation of lawyers thinking about rights of nature in relation to climate change. But how can we translate to actual practical policies that affect people's lives? So that takes time. And sometimes people are not willing to be patient to find how to implement that. So yeah, I would say those are some of the challenges we've been facing.
Thank you, Gabriela. There's another question, a couple of questions I can see. One is from Eric Pajares, the Biosphere Group in Peru, for Gabriela, asking, in the lawsuit against the Colombian state, what is the basis for considering future generations as subjects of legal rights? And I have Geoff next in the queue. Perhaps we'll just collect a few questions and then we can try and cluster and address them together. So Geoff, if you want to ask your question as well.
Thank you all very much for your presentations. It's a great topic. As someone who was born and have most of my
Geoff, we can't hear you. The voice cut out.
boy.
Yes, we can. Geoff, we lost you for a bit. Would you mind repeating the question?
Yeah,
Geoff,
limitations on rights-based approach, in regional. I'm going to write my question in the chat.
Okay, great, thank you. Gabriela, do you want to take the first question while we are waiting for Geoff's question?
Yeah, sure. Great question, thanks. So for the Colombian case, we use two legal sources. First, the preamble of the Paris Agreement that mentions intergenerational equity. And second, our national constitution that establishes the duty of the state to work towards sustainable development. So we went back to the Brundtland report to explain the judge what sustainable development means and who are the stakeholders, the main stakeholders in sustainable development. So using our right to a healthy environment, the mention to sustainability, and the framework of the Paris Agreement, we said that people who were living their teenage years and early adulthood at the time we filed the lawsuit were part of that future generations concept.
Thanks, Gabriela. Geoff, do you want to unmute yourself and go next, or type it in the chat?
Yeah, I'm afraid with snowstorms and things, I'll just type my, I don't know how I'm coming across orally, so I'm just going to type it in the chat.
Okay, you're very clear right now, if that helps.
Okay, so I was pointing out that rights-based approaches seem strong in Latin America and Europe, and yet you have pockets, major problem areas like the US and China where they're not so strong. So, how can we, what's the potential for a globally coherent approach based on human rights? And if it's not so possible, at least in the short term, how can we fit in things like in the United States, even where we have hopes for stronger climate legislation, the US, when it started regulating greenhouse gases under the Clean Air Act, made an endangerment finding that, recorded officially the threat that climate change poses to human health, which is what's required under the Clean Air Act. So you have some potential there for something that's not really rights-based, but may work in the mix. So I'm just wondering if anybody, maybe any of you that have thoughts on how we can patch together something that's coherent, even when we have places that aren't so strong in rights-based approaches.
Does one of you want to take it? I have a quick thought on it, which is what I found interesting with cases like even Juliana, for example, which were arguing on, it was, the lawyers in the case were very clear that although they weren't necessarily citing human rights as a source, the arguments were largely analogous because they were talking about children's right, a right to life. And I think what is interesting about some of those approaches is that there seems to be a shared vocabulary that is also as much the content as the form. So even if the US is largely sui generis in some ways, and I think it's because it's seen as a certain legacy of rights claims that already exist in the country, that human rights, there's certain perhaps discomfort with that language. But the content of the rights that were being requested, and the lawyers in the case were very clear that they specifically did not want to make a technical claim. They specifically did not want to make a claim under environmental law, statutory environmental law. They were looking for a rights-based claim because they believed that what they were asking was something more than a very sort of technocratic approach towards rights. So I think that there is a shared vocabulary. Maybe this is just me being optimistic, but I don't know if Professor Voigt or Gabriela have different thoughts on that. I can also see another question, so maybe we'll just, I think Massimiliano would like to ask a question next, and then there's a question in the chat. So Massimiliano, the floor is yours.
Hello. Hi, everybody. It's a pleasure to be here with you. I have a couple of questions which are somehow related to, one is to all of you. My concern with obviously I've been following all these cases with great interest, and I think it's a great, it's a great time that these cases are actually now in most courts or many courts all over the world. I'm a bit concerned that all these movement, I understand obviously the reasons for being based on human rights litigation, all these cases, but there is a risk that all of this climate litigation is a bit too anthropocentric in the approach, and there is not so much room for the nature perspective into that. And the question for all of you maybe is, how would you think we could rebalance that? Maybe it is in the bit in the Colombian perspective, but not so much in many other cases around the world. This is the more theoretical question. And within that, maybe this is more a question for Christina, who has been following the mostly, let's say, the European perspective. I have the impression that in Europe now, in many countries, there is a tendency to say, okay, now we will take these CO2 reductions seriously, also because this will be backed by European funds related to the Next Generation EU. This is much more a European issue. And for example, in countries like Italy, it starts emerging a debate that there might be an inclination to say, let's go for CO2 reduction at any cost, whatever it takes, which might be dangerous in some respects for traditional nature conservation, because there might be a tendency to put nature conservation in the second rank as compared to reduction of CO2 at any cost. I would like to know the opinion of all of you, obviously, on these, but in particular, maybe Christina Foito has been following the European debates on that. Thank you.
Thank you. I'll just read out another question and then maybe we can have a round of responses. Carolina Garrido is asking, what do you believe can be important indirect effects of using rights-based litigation, especially beyond the courtrooms? Gabriela, Professor Voigt, do you have responses to either of the questions?
If I can start with Massimiliano's questions, that were really excellent questions. And the first one on the anthropogeneity of human rights. Of course, that's kind of criticism that is often launched against bringing human rights into any environmental challenge. And you look at an environmental challenge through that anthropogenic or the anthropocentric lens of human rights, and certain aspects that are cut off necessarily because you look through it from an human-based perspective. And I think some of that criticism is very, very valid. But at the same time, going back to that list of reasons that Shalini very excellently lined out, I think there's a lot of value in also pursuing it, but it shouldn't be the only avenue. I think exactly like the Colombian case showed us, there are different avenues, different arguments to be had. And in that particular case, it was both a human rights based litigation, but also it led to the recognition of the Amazon as being a legal subject in its own right. Whether that enhanced the implementation or not, by the end of the day, is something that Gabriela shared with us some criticism with. But of course, using the avenues that we have to pursue a goal that we all share is maybe something that we should try nevertheless, but also pursue innovative and newer challenges or channels that open up. But as you rightly said, Massimiliano, there is still a lot of work to be done in order to, for example, in the European setting, to put forward or even win a rights for nature-based claim. I wouldn't be able to immediately see any court within Europe that would be amenable, but maybe it's just a matter of time and a matter of other parts of the world going forward with it and showing where the law can and should develop to. The second one, CO2 reductions at any cost. I think that's a very important one. It's kind of a environment against environment against social consideration kind of balancing question. And I think here, something that I tried to explain a little bit in my talk was the question of what are reasonable and appropriate measures, because these are very general terms and they need to be filled with meaning in any particular case. And in any particular case, they would have to look into balancing of different objectives and different interests and open up for that kind of balancing. And it shouldn't all go into the climate measure that would not look at any other side effects or environmental or social impacts. That can definitely not be the case. But I think we have legal tools that enable us as academics or judges that would have to decide a case to do that weighing of different interests. And we've seen that very clearly in Norway, where the weighing sort of switched to the other side, but it was exactly based on that kind of looking at different interests and finding the balance somewhere in the middle.
If I may, I would like to add something to the first question. That is something that the Supreme Court of Colombia discussed in the decision. So they question how were we approaching the climate change problem from an anthropocentric point of view, and how the legal system we had in place was not enough to deal with the complexity of this problem. So the judge said that it would be necessary to have a biocentric or even an ecocentric approach, and that is why without having rights of nature in our legal system, in our legislation, it decided to grant the Amazon with rights. Because in the way I understand this is that when we're talking about climate change, we're not only talking about the increase in greenhouse gases. All these cases have something behind, and is a broader question to our model of development. How we have been structuring our economic models and political models to develop in a way that damages biodiversity, that damages the other sentient beings with whom we share this earth. So what has happened in Latin America, at least, is that judges do not find enough tools to deal with these complex problems, and they go to the rights of nature concepts and discourse to try to fix the problem. Now, the challenge for us is to understand what does it mean to have rights for these entities.
Massimiliano, I saw you unmuted yourself. Do you want to add something?
Yeah, thanks a lot. I think it's it's very useful. You reacted to that, and I hope we will have more opportunities in the future to discuss on this, because I'm really interested to see how this all develops. So thanks a lot to all three of you. Just I take the opportunity to say that.
Thank you. I just want to quickly return also to Carolina's question about the indirect effects of using rights-based litigation, especially beyond the courtroom. And I was wondering, Gabriela, since I know we've discussed this in the past, if you had particular thoughts on it.
Thanks, Shalini. Yeah, I would say that there are some positive effects. The symbolic effect of having like the public discourse turn into the climate change urgency is something important. At the same time, there are many stakeholders that are left out of these cases. So when you focus on children and youth, you might be missing vulnerable communities whose activities depend on natural resources, this is the language that the governments usually use to refer to nature, so natural resources. And what has happened in Colombia is that there is increased awareness on climate change and how that affects future generations, but also the response from the government has been hurting smallholder farmers, or even not taking into consideration indigenous communities' views. So that's why I'm really into understanding better how can we implement these cases in a way that everyone who has a stake is involved in the decisions. So you could say that there are positive and negative indirect effects.
If there are no questions from the floor, I will abuse my moderator privileges and ask Professor White a question. I know we briefly discussed about this before, and I was really curious about your thoughts on what seems to be a new wave or a trend, which is the cases against private corporations. It's of course quite different perhaps in the three jurisdictions where we've seen it, in the EU, in the Philippines, and the cases in the US. And I was wondering if you had thoughts on how these cases really align with the other more traditional cases and where this sort of litigation might be going.
That's a good question, Shalini. I think what we're seeing is kind of a second wave of litigation. That is the first wave being directed at governments, at states, and now we are seeing corporations being targeted more and more, and it's worthwhile considering it, and I think very important. It's just that the cases are very different. Many of the claims are very different. There's some similarity, but primarily they're based on for example, many cases in Europe that are based on OECD guidelines, for example, or on consumer protection, matters of how you promote yourself and disenfranchised. So they're very different kinds of cases. But what we're seeing is definitely a, how can I say, all hands on board litigation. We have very active community of litigants, of lawyers worldwide who talk to each other, who try different things, who try different arguments in different jurisdictions against different respondents, and that is just resembling the complexity of the climate challenge, because there's so many contributors in so many different ways from all sectors. I mean, Gabriela talked about the land sector and the forest sector in Colombia and other countries. Major part of the emission come from different sectors. So it's just reflective of the complexity of the challenge, that we also see that in the way litigation is now staggered out.
Thank you. Katie has a comment on hoping that the disinformation cases affect the climate change litigation as well. That's, I think, particularly interesting in the US, and I know they're modeling the cases behind the tobacco and the opioid cases. So it'll be interesting seeing what happens there.
Yeah, I think you have very interesting cases against major oil companies. You have in Europe that are based on misinformation, miscampaigning, greenwashing, drawing a picture that they're not really is not corresponding to the reality of their business model, and that kind of case law is just up and coming, and you see it can be applied to a whole range of different companies. But what I'm saying is it's a very different type of cases than the state targeted litigation.
Absolutely. Are there any other questions? Then I'll turn to the co-panelists for final closing thoughts, and maybe Katie can say a few words. Then I think we're almost at time, so it's 5 minutes left to go. There is a peculiar silence of the Zoom room, which is always interesting. I see Alessandra has a final question. So Alessandra, I think yours will be the final question, and then we'll maybe move towards wrapping up.
Yeah, thank you, Shalini. I was just wondering, because I thought it was very interesting, the thing that Gabriela said about the fact that climate change isn't only a problem of reduction of greenhouse gas emissions, but we can link climate change to biodiversity loss. And my question would be, and also she linked this to the fact that we have this particular way we think about climate change. We usually, or about nature, because we link it to how nature is beneficial to human beings, right? Like in this kind of Western conception of environment and nature. And so my question would be, do you think that the use of human rights as a framework in a way undermines this objective of going beyond the conception that we need to think about the environment only because it's beneficial to human beings? In a way, we are using a framework that is based on human beings. So yeah, I mean, my question would be, do you think that this kind of undermines the aim of linking climate change with biodiversity loss and the protection of nature beyond what is only beneficial to human beings? I hope that was clear.
Yeah, thank you very much for that question. I think it does not undermine the idea of rights of nature, because at the end of the day, that is the only framework we have. Like, if you don't use human rights to talk or to question our relation to nature, what other tools do you have within the legal system to do so? So what I found interesting is that different lawyers and legal scholars and judges are starting to question our relation to the environment and to nature, and how we interpret human rights not as islands, but as part of a bigger system in which we coexist. So I think if you don't use human rights framework, you would be just in an academic framework, and it would be even more difficult to put into practice this idea of rights of nature.
Thank you.
I couldn't agree more with what Gabriela just said. I just wanted to comment that these are not mutually exclusive. You know, as Gabriela said, the human rights system has been around for many decades, and it kind of predates the more current idea about legal entitlements of environmental aspects. It's there, it can be used. And in addition, we can, you know, explore other avenues, and maybe some more work needs to be done to carve them out. Or maybe we need to find enlightened judges who understand or who look for different arguments. But just because the human rights avenue is being pursued, it doesn't mean that, you know, we cut ourselves off from pursuing other things, maybe at the appropriate moments in time, or at the same time, like the Colombian case showed, where it was possible to use both types of arguments.
Thank you again to Professor White and to Gabriela. This was fascinating. I learned a huge amount. I just wanted to quickly wrap up because we're at time by saying that next month's webinar will be on Tuesday, March 16th, and it will be on ecological law and degrowth, hosted by the leadership for the Ecozoic project of McGill University. We very much hope to see many of you there as well. Take care. Thank you all again for coming, and hope you all have a great rest of the day wherever in the world you are. Thanks very much. Bye.
Thank you so much.
Thank you.
Thank you.
Thank you, Shalini.
Thanks a lot.
Bye, everyone.
Bye-bye.